Hello folks, this is Abhinay Gupta from Edipedia World, and today we'll switch to a very interesting topic, which is the declaration and payment of dividend. The topic of declaration and payment of dividend may or may not be so interesting for students, but definitely dividend is the most interesting part for the investors. So, today we'll cover the entire law, the Companies Act, behind the declaration of dividend. Chapter 8 of the Companies Act 2013. To be more specific, the 5 sections, section 123 to section 127, deals with the entire procedure behind declaring and paying the dividend to the investors. The Companies Act 2013 is supported by the Companies Rule 2014 for this purpose also. And the very specific rule for this is again the Company's Declaration and Payment of Dividend Rule 2014. So to start with this chapter, the first basic fundamental that we need to know is what does the dividend actually mean? The meaning of dividend. So in a layman's term, dividend is what the shareholder gets for his investment. It is the return on the investment of the shareholders. And what we need to definitely keep in mind is that dividend is a proportion of profit only. Okay, now let's put it this way. Now there's a company, right? The company is managed by the board of directors but funded by the shareholders. The shareholders are the basic investors. They are the basic reason why a company exists. If the company has no funding, the company goes nowhere. The directors won't be there to manage the company. They're not getting the salaries. There's no manufacturing activity, there's no production, there's nothing. The basic element that you need to do in a business, that you need to run any company, is the finance. And the finances are the shareholders. So if a shareholder brings in his money into any company, they can invest in n number of companies. Then there's something that the shareholder wants in return, and that is the dividend. They want a share of the profit, which should be in proportion to their investment into the company. If there is a particular shareholder who holds 20% of share of the company, that means he had made the 20% investment in the company. So he wants the 20% of the profit, the distributable profit, the dividend of the company. That is the basic reason why a shareholder invests in a company. Yeah, obviously there are other reasons like the growth, the economic benefit, the diversity, but those are separate issues and those will be covered in your strategic financial management and accountancy. In your corporate and allied law, what we will basically be covering is the legal aspect of the declaration and also the payment of dividend. Its calculation, its working, its accounting effects won't be dealt in law, right? So the board of directors, they are the people who run the company. They are the people who do all the strategic financial management of the company, the financing, the decision making. Obviously, they'll have to get the consent of the shareholders before making major decisions, but they are the main sole body who runs the company. And shareholders are the main decision makers. But this decision of declaration and payment of dividend has not been vested upon any one of them individually, because that will always be biased. Let's take it this way. If a shareholder gets the whole and sole power to declare dividend, he will obviously declare as much as dividend as he can. The maximum amount of profit will be declared as dividend. There will be no retained earning for the growth of the company. That is because if I have the power to decide how much I'll get, I'll take the maximum. And on the other hand, if we talk about the board of directors, they will not want to declare any dividend because that is the profit going out of the company. They will want to retain it and grow the company further in the next year. So in both the ways, if the decision for declaration and payment of dividend is left in the hand of any one of them, it has to be biased. So the Companies Act 2013 as well as the old Act 1956, they have almost the same provisions. They have divided the responsibility and the power of declaration and payment of dividend amongst the board of directors as well as the shareholders. So we'll deal with it, how the procedure moves ahead. First, we need to know what are the basic types of dividend. Dividends are basically of three different types: the proposed dividend, the final dividend, and an interim dividend. Now, what is a proposed dividend? After the operations of the company is done, the board of directors are in a position to estimate or take economic decisions. They have the route map in their hand. They know the progress, they know the working, they know the market. That is the time when they decide, okay, this is the amount we need to retain out of a profit for our future investments, for the growth, and this is what we can give out as dividend to the shareholders. And then after they have analyzed how much dividend the company wants to give to its preference shareholder or equity shareholder or whosoever, then they propose a dividend. Then they hold a board meeting and they decide that, okay, this is the specific percentage of dividend that we can let out this year. That may be 5%, 10%, 20% of profit, whatever the figure be. But this figure, when proposed by the board of directors, is called the proposed dividend. This is not what the shareholders will actually get. This is what the company can give. This is what has been estimated by the board of directors, that yeah, this is how much we can let out of our profit for the shareholders. Second is the final dividend. Now once the shareholders, the board of directors, they propose the dividend, the next step is to get it confirmed, get it affirmed in the shareholders meeting, specifically in the EGM. So the proposed dividend, when consented by the shareholders at an annual general meeting, becomes final dividend. Now the percentage of dividend in this case may be equal to what was proposed or maybe less than what was proposed, but the shareholders have not been given the power to increase the percentage of the dividend which was proposed, because the board of directors have already announced or have already proposed the maximum dividend that they can give. If the shareholder wants, they can take it away. If they won't, they can again say, okay, no, we want you to keep another 5% as retained earning and we'll take the rest. And that is the decision that will be taken in the annual general meeting of the shareholders of the company. The third kind of dividend is the interim dividend. This is given out in the middle of the year. And this is where the rules slightly change. This is the dividend which is again declared by the board. It is not recommended or it is just not proposed. It is declared by the board. Mark the word declared. For a particular financial year, but not at the end. It is declared during the financial year. This is when it is called interim dividend. So the interim dividend is a dividend which is declared in between two annual general meetings. Unlike the proposed and final dividend, which are actually proposed and finalized and distributed at the end of the financial year, finalized at the annual general meeting only, and the powers are equally divided between the board of directors and the shareholders. But interim dividend is declared by the board, given out during the year to the shareholders. So this is slightly different than the concept of dividend that we were discussing about. Right, folks? Yeah, so far what have we noticed? Let's conclude it in a nutshell. Declaration of dividend. Even the regulation 80 of table F say the same thing. They say that the company in the general meeting declares the dividend, but no dividend shall exceed the amount recommended by the board. These are the wordings of regulation 80 of the table F. So there are 4 basic points that are worth noting in the discussion that we have made so far, which is that the power to declare dividend rests with the members. And remember, when we are talking about dividend in general, we are talking about the final dividend and not the interim dividend. Because as per the definition of dividend also, dividend includes interim dividend, right? But over here, in general terms, we are talking about the final dividend. Wherever we talk about interim dividend, we will make it specific that yeah, we are talking about interim dividend. Okay, so the dividend are declared by the members, but it is declared only if it is proposed by the board, which means that board, along with deciding the percentage of dividend, will also decide whether or not to give out dividend in a particular year. If they don't want to give out a dividend, they'll just state 0%. What less than that now? So, and another important remarkable point was that the rate of dividend proposed by the board may be reduced by the members at any point of time. They say, okay, we are ready to give out 10%. The members will say, no, we'll take only 5%. Another point is that it cannot be increased by the shareholders. And another thing that you need to notice in this is that these are the powers given by law, given by the Companies Act. So any provision in the article which authorizes the member of the company, the shareholders of the company, to declare the dividend at a percentage higher than what was declared, what was proposed by the directors, will be void ab initio. It has no standing at all, because article cannot at any point of time overrule the law. It cannot set aside the provisions of law. So we talked about Regulation 80, we talked about declaration of dividend in general meeting. Now, yeah, the general meeting means general meeting. If at any point of time the company is not able to declare dividend in an annual general meeting, then they can do that in the subsequent extraordinary general meeting. It is not compulsory to make it in annual general meeting, right? It can be done subsequently in the upcoming extraordinary general meeting. So now what is the difference? If the dividend is declared in an annual general meeting, that will be considered as the ordinary business of the company, because dividend is supposed to be declared at the annual general meeting. So it's ordinary business. And for ordinary business, you pass an ordinary resolution, right? But if it is like passed in the subsequent extraordinary general meeting, then that is a special business for the company. It is a specific circumstance in which it was passed in the extraordinary general meeting. And so to decide the percentage of dividend, they will have to pass a special resolution, unlike the annual general meeting, right? And the maximum limit we know. And the important part is that the dividend can be paid to partly paid shares also. But that is on the discretion of the company if they want to give it out. And that will obviously be in proportion to the amount paid for the shares. Like if you have paid 5 rupees for a 10 rupee share, you will get the 50% of dividend. If dividend is rupees 2, you will get rupees 1. It's a simple calculation. And this topic that we just discussed about Regulation 80 and the declaration of dividend was recently asked in your 2008 CA final examinations, November. So yeah, it's not a light topic. You may be asked questions on the same in future also. So that was all for the day. We'll continue the topic in our next lecture. Thank you so much. This is Abhinav Gupta signing off. Thank you.